Have you ever wondered about the quiet mechanics that keep a nation running, even during its most profound, maybe even revolutionary changes? Today, we're taking a deep dive into some of the most often overlooked yet, well, utterly foundational corners of India's constitution. These aren't the articles that grab headlines, but they are absolutely the bedrock, the structural steel, really, that holds the entire edifice together.
Indeed. We're embarking on what I think is a fascinating journey through Part 9, Part 71, and then concluding with Part 62 of the Constitution of India. Our mission for you, our listener, is to truly elaborate, explain, analyze, and illuminate these critical articles, understanding their very nature, their underlying object, their, well, extensive scope, real-world application, and the nuanced interpretation that legal scholars apply. We'll break down their basic ingredients, dive into some compelling real-world scenarios, and trace the landmark case laws that have, frankly, profoundly shaped their meaning and impact over the years.
Think of this deep dive as your exclusive backstage pass, really. You'll gain not just knowledge, but a true understanding of how India, as a nascent republic, navigated its tumultuous birth, managed seamless continuity, and enshrined crucial protections, sometimes in remarkably ingenious ways. You're about to uncover constitutional fine print that has an outsized importance, giving you those aha moments that connect the dots on how a modern nation's legal framework truly operates. It's about gaining quick yet deeply thorough knowledge on the essential building blocks of governance and law that continue to resonate today. Okay, let's unpack this journey by starting with Article 361. At its core, this article is about personal immunity for the president and governors. Now, saying immunity sounds, well, dramatic, but why is this so crucial for these high offices? Is it really about the individual or, something more?
That's a great question, and it's a key distinction. The nature of this protection is intensely personal to the incumbent. It's not an immunity for the office's actions itself. This shield is vital because it upholds the dignity and, perhaps more importantly, the independence of these high constitutional offices. Imagine the chaos if the president or a governor could be dragged into court for every decision made, or even for personal accusations, while trying to run the country or a state. It allows them to perform their constitutional duties without the constant threat of harassment or vexatious litigation.
So it's about protecting the person from undue distraction rather than insulating the decisions from scrutiny. That feels like a very delicate balance. How does the Constitution actually achieve that?
Precisely. And the scope of this immunity is multi-layered and quite meticulously defined. Clause 1 protects them from being answerable to any court for official acts, meaning for the exercise and performance of the powers and duties of their office. It's a shield for the individual in their official capacity. But here's the brilliance, really. A crucial proviso ensures that while the individual is protected, governmental actions are still accountable. You sue the government, the Union of India, or the state, not the individual president or governor. That preserves the principle of governmental responsibility.
Ah, okay, so the government itself isn't immune.
Not at all. Then you have Clause 2, which provides absolute immunity from criminal proceedings whatsoever. It prohibits their institution or continuation during their term of office.
Rare.
This is a pretty robust shield.
Absolute immunity from criminal cases. Wow.
Yes, while in office. And Clause 3 further ensures no process for arrest or imprisonment can be issued from any court during their term. Finally, Clause 4 addresses civil proceedings for personal acts, actions taken not in their official capacity. Here, the immunity isn't absolute. Instead, it introduces a procedural step. A 2-month prior notice must be served before any civil proceedings can be instituted for acts done by them in their personal capacity. This applies whether the act was done before or after assuming office. So this detailed layering clearly distinguishes between official and personal capacities, offering different types of protection for each.
So if I'm understanding this correctly, the object of Article 361 is crystal clear. Ensure these leaders can focus on their immense constitutional responsibilities, free from the constant shadow of personal legal battles. This protection is vital for maintaining the operational independence and, well, dignity of the highest executive offices in our federal structure. And this isn't just for their term in office, right? Does protection for official acts continue even after they step down?
That's a critical point for the article's applicability. You're right. The immunity from criminal proceedings and arrest applies strictly for their term in office. However, the immunity for official acts, those performed while discharging their constitutional functions, persists even after they leave office. This ensures that leaders aren't held personally liable for decisions made in good faith during their tenure, even after they've transitioned out of public service. It promotes decisive governance in a way.
Okay, that persistence is important.
It is. To illustrate, imagine the president issues an ordinance that, say, a political party believes is unconstitutional. You can certainly challenge the ordinance itself by suing the Union of India, but you cannot personally sue or summon the president to defend their actions in court. Or consider a scenario where a serving governor is accused of a personal financial offense from before they took office. No criminal FIR can be registered against them, nor can any criminal prosecution proceed while they are in office. That bar is quite comprehensive. Now, for a property dispute against a governor for an act from before their term, a civil suit would require that mandatory 2-month notice before it can be filed. This balance, though, it does raise an important question. How do courts reconcile this powerful personal immunity, which shields the office holder, with the paramount principle of governmental accountability and the rule of law?
That's a profound dilemma, isn't it? It sounds like a constitutional tightrope walk. How did the Supreme Court actually navigate that, especially when faced with controversial executive decisions?
Precisely. And this is where we see the judiciary stepping in, interpreting this power, recognizing its importance but also its limits. Take the landmark case of Rameshwar Prasad and Ors, Sikhs to the Union of India and Honor from 2006. That dealt with the dissolution of the Bihar Legislative Assembly. The Supreme Court observed that while the individual president or governor enjoys immunity, this immunity under Article 361.021 does not bar the court from examining the validity of the action itself, including on grounds of malafide, meaning bad faith or ulterior motives. The court can scrutinize the materials, the reasoning, to assess if the decision was based on extraneous considerations. It doesn't shield unconstitutional acts of the office itself.
Okay, so the action can still be challenged.
Exactly. Similarly, in Common Cause, a registered society v. Union of India, 1999, the court reiterated personal immunity, but clarified that governmental actions are absolutely not beyond judicial review if found to be malafide or ultra-virus, that is, beyond legal authority. The government, as an entity, can always be sued. So what this means for us is a delicate yet crucial balance. It underscores a limited form of sovereign immunity, though maybe more precisely, a constitutionally delineated personal immunity balanced meticulously with the crucial accountability of government, all while upholding the dignity of office. It's a mechanism designed to protect the person holding the office without ever insulating the power of the office from constitutional scrutiny.
That's a brilliant insight into how India's framers shielded its highest office holders from personal harassment vital for their independence, yet ingeniously ensured that governmental decisions never escaped judicial scrutiny. Now let's take a fascinating detour into history with Article 362. This one is particularly intriguing because, well, it no longer exists. It was a provision specifically designed to protect the personal rights and privileges of the rulers of Indian states. Tell us more about its original purpose and why it's gone today.
Article 362 was truly a product of its time. It reflected the explicit assurances given by the Union government to the rulers of the nearly 560 princely states during their integration into the nascent Indian Dominion. The promise was that due regard would be had to their personal rights, privileges, and dignities in the exercise of legislative and executive power. These guarantees were often critical, actually, to securing their accession, ensuring a smooth transition during a truly complex period of nation-building. It was a constitutional safety net for historical commitments.
It sounds like a pragmatic necessity for unification, but if it was so important, why did it ultimately get repealed? What philosophical shift drove that change?
That's where the bigger picture of India's evolving social and political philosophy comes in.
Yeah.
Article 362, along with Article 291, which dealt with privy purses, was seen as, well, a transitional arrangement. However, over time, the existence of special constitutional rights, privileges, and dignities for a class of citizens, the former rulers, became increasingly incompatible with the vision of an egalitarian, democratic social order, the very vision enshrined in the Constitution itself. The argument was that such hereditary privileges ran counter to the principles of equality and social justice.
Right, the core values.
Exactly. Consequently, the Constitution, 26th Amendment Act, 1971, was passed. This amendment definitively abolished Article 291 and Article 362, thereby extinguishing the privy purses and all related rights and privileges of the rulers. It was a significant step towards reinforcing democratic and egalitarian principles, shedding the last remnants of a feudal past, and aiming for a greater social equity in a modern republic.
So it was a move to flatten the hierarchy, constitutionally speaking. Even though it's repealed, the lead up to that amendment involved one of the most famous clashes between the judiciary and the legislature in Indian history, the Privy Purses case. Can you walk us through that landmark decision and its aftermath?
Absolutely. The Privy Purses case, formerly H. Maharaji Jivajirao Scindia Bahadur and Ors v. Union of India, decided in 1971. The Supreme Court, in a significant judgment, initially struck down the presidential order that derecognized the rulers and stopped their privy purses. The court held that privy purses were in the nature of property rights and that the presidential order was an executive act that couldn't unilaterally extinguish such rights without constitutional amendment.
So the court initially sided with the rulers.
It did. The Parliament, however, responded swiftly to this judicial pronouncement. Believing that the privileges and privy purses were indeed anachronistic and inconsistent with the nation's democratic values, it utilized its constituent power. Within months of the Supreme Court's judgment, the 26th Amendment was passed, definitively abolishing Articles 291 and 362 and extinguishing all rights, liabilities, and obligations related to privy purses and former rulers. This was a powerful, albeit dramatic, example of the interplay between the judiciary and the legislature. It demonstrated the ultimate supremacy of the constituent power, Parliament's amending power within its recognized limits, to definitively alter the legal landscape after a judicial pronouncement.
A truly impactful historical episode that reshaped India's social fabric. Now let's turn to Article 363. This article presents a very specific no-go zone for courts. It essentially tells them, courts, stay out of disputes arising from those old treaties with princely states. Why was such a comprehensive bar necessary, and what was its underlying nature?
Article 363 is a powerful expression of what's often referred to as the political question doctrine, or maybe the act of state doctrine, within the constitutional framework. The framers recognized the inherently political nature of the settlements that integrated the, hundreds of diverse princely states into the Indian Union. Hundreds of treaties, covenants, agreements were signed, and disputes arising from these were considered best resolved at an executive or a political level rather than through endless adversarial litigation in courts. This ouster of jurisdiction is quite comprehensive, applying to all courts, including the Supreme Court.
So it aimed to prevent the new republic from getting bogged down in historical claims. What are the basic ingredients that define the scope of this bar? What exactly does it prevent courts from doing?
Well, the bar operates notwithstanding anything in this Constitution, giving it overriding effect over other judicial jurisdiction provisions. However, it's crucial to note the exception for Article 143, which allows the President to consult the Supreme Court for an advisory opinion on such matters. That provides a specific safety valve for complex questions. The bar applies specifically to disputes arising out of any provision of pre-Constitution instruments, treaties, covenants, engagements, sedans entered into by rulers of Indian states with the Dominion of India. It also covers disputes regarding any right or liability accruing under constitutional provisions relating to such instruments. The definitions of Indian state and ruler in Clause 2 tie it intrinsically to that specific historical context of princely state integration. Its scope is precise, you see. Not a blanket bar on all matters concerning former rulers, but strictly focused on disputes directly emanating from these political acts of integration and accession.
The object, as you said, was clearly to give finality to those massive political settlements. It must have been crucial to prevent the fledgling republic from being overwhelmed. So, in a practical scenario, what kind of dispute would Article 363 definitely bar, and where might courts still find jurisdiction?
Okay, consider this. If a descendant of a former ruler files a suit purely based on the interpretation of an old, perhaps vaguely worded personal guarantee within a covenant of merger, seeking to enforce a historical right strictly arising out of that original political document, Article 363 would likely bar it. Similarly, a dispute about the precise territorial extent of a former state based on a merger agreement from before the Constitution's commencement would probably fall under this bar.
Right. Direct connection to the old agreement.
Just exactly. However, the judiciary has generally interpreted this article narrowly. They want to ensure that genuine legal rights, especially those created or recognized by post-Constitution laws, are not arbitrarily excluded from judicial review. For instance, if new rights are created by post-Constitution laws, even if their historical origin is indirectly in those covenants, courts might step in if the dispute is not directly arising out of the original agreement. This raises an important question. How do courts carefully balance respecting these historical political settlements with the evolving legal rights of citizens in a modern constitutional democracy without entirely abdicating their role as guardians of the law?
That's a critical distinction, the directness of the dispute to the original agreement. This sounds like the judiciary carved out its role carefully. What case laws exemplify this interpretation?
The judiciary has indeed interpreted this provision very strictly. In Virendra Singh and Or's The Estate of UP 1954, the Supreme Court emphasized that Article 363 must be strictly construed. It doesn't bar judicial review of post-Constitution executive actions or legislative enactments that might affect rights unless the dispute directly arises from the agreements themselves. The court ensures that an executive action that potentially violates the Constitution, even if it touches upon matters related to former princely states, isn't automatically immune.
Makes sense.
And we return to our Privy Purses case, Madhav Rao, Javaji Rao, Scindia Bahadur, and Or's v. Union of India, 1971. A majority of the Supreme Court held that the presidential order derecognizing the rulers was an executive action, not a dispute arising out of the covenants. And thus, Article 363 did not bar judicial review of that order. Further, State of Gujarat v. Warafidali Badruddin Miti Barwala, 1964, clarified that if private rights are claimed by citizens and the dispute doesn't directly touch upon the political act of the covenant, Article 363 may not apply. This legal journey demonstrates how the courts apply the acts of state doctrine and the political question doctrine, recognizing certain matters as non-justiciable due to their political nature, but always with a strict interpretation of any ouster of jurisdiction clause. This preserves the vital role of judicial review where applicable, all while affirming the supremacy of the Constitution itself.
Having seen how the Constitution dealt with the legacy of princely states, it's fascinating to pivot to how it empowered the executive to manage critical national assets like ports and aerodromes. That's where Article 364 comes in. This is a very specific, powerful provision, giving the president special authority over these vital pieces of infrastructure. How does it work, and what's its nature?
Article 364 is indeed a specialized tool. It allows for, well, what you might call executive legislation in a very conditional sense. It grants the president the power to regulate these critical national assets, recognizing their unique strategic importance for national trade, transport, and defense. The very nature of this power is that it allows for a tailored legal environment, free from the general laws that might otherwise hinder their specialized functions. This is not a general executive power, it's very targeted for high-importance infrastructure.
Tailored legal environment sounds intriguing. What are the basic ingredients that give this power its weight and define its scope?
Well, the power is exercised by the president via a public notification, meaning it's a formal, transparent act. The critical phrase here is, notwithstanding anything in this Constitution. This gives it immense weight, indicating its overriding effect over other constitutional provisions related to legislative power, including the distribution of legislative subjects between the Union and states. The president can direct that any law, whether enacted by Parliament, the state legislature, or even existing pre-Constitution laws, either won't apply to a major port or aerodrome or will apply only with specific modifications. Clause 2 ensures that the terms major port and aerodrome are defined by reference to existing enactments or parliamentary laws, keeping the scope tightly regulated to those truly strategic areas.
So the object is clearly efficient administration, development, and security. It's about flexibility and speed in managing infrastructure vital for the nation. Can you give us a concrete illustration of when this power might be used?
Absolutely. Imagine a scenario where a state's local building bylaws, or say municipal regulations, are found to be impractical or actively obstructive for the rapid expansion and modernization of a major port within that state. The port needs to deepen its channels, build new terminals, or expand its logistics facilities without undue delays from local bureaucratic hurdles. In such a case, the president could issue a notification under Article 364, modifying or even excluding the application of those specific state laws within the defined port limits to facilitate the development, all without having to wait for a full legislative amendment.
Right, much faster.
Exactly. Or for enhanced security measures at a bustling international airport, certain provisions of General Police Acts might be applied with modifications, or even excluded, to allow for specialized, highly controlled security regime specific to the airport's unique operational needs. This highlights a fascinating tension, though. How do we ensure such a potent executive power, capable of overriding legislative enactments, remained accountable and is used judiciously while serving paramount national interests? While there isn't much direct case law on this, judicial review would undoubtedly consider if the notification exceeded the defined scope or was arbitrary, adhering to the principle of limited government.
That's a powerful and practical mechanism for a developing nation. It really highlights the idea of specialia generalibus derogant, that special provisions prevail over general laws. It's rooted in ideas of national interest and strategic importance, allowing this conditional executive legislation for very specific and crucial areas. Now, let's pivot from direct executive power to a constitutional lever that impacts union-state relations significantly. Article 365. This provision acts as a potent sanction, making a state's failure to comply with union directives a potential pathway to president's rule under Article 356. It's a powerful deeming provision, allowing the president to draw a constitutional inference. Why was such a provision deemed necessary?
Article 365 is indeed a testament to the framers' understanding of the need for union primacy in certain critical situations, especially in a federal system with diverse states. Its basic ingredient is quite straightforward. If a state fails to comply with, or to give effect to, any directions given by the Union in the exercise of its executive power under any provision of the Constitution, for example, under Articles 256 or 257, which empower the Union to issue administrative directions to states, that it shall be lawful for the President to hold, that a situation has arisen where the government of the state cannot be carried on in accordance with the provisions of the Constitution. This is a crucial precondition, really, for invoking Article 356. The scope is broad, covering various aspects of union-state administrative relations, ensuring a robust mechanism for union oversight and the implementation of national policies.
So the object is clearly to ensure effective implementation of union policies, maintain union supremacy, and provide constitutional grounds for intervention if non-compliance genuinely leads to a breakdown. Can you give us a vivid illustration of how this might play out and what important question it raises?
Okay, imagine a situation where Parliament passes a law on interstate trade, or maybe a critical aspect of national security. And under Article 256, the Union issues specific executive directions to a state to implement that law, perhaps by setting up certain administrative structures or enforcing particular regulations. If that state stubbornly refuses to take the necessary executive actions, effectively, sabotaging the parliamentary law's implementation, the president could then lawfully hold under Article 365 that the state isn't functioning constitutionally. This then lays the groundwork for further action under Article 356, potentially leading to the imposition of president's rule. Similarly, if a state fails to take measures for the protection of railways or national highways as directed by the Union under Article 257(3), leading to significant disruptions, it could potentially trigger Article 365.
Right.
This raises a profoundly important question, though. How can we balance the need for union supremacy, which is vital for national coherence and the integrity of federal laws, with the federal structure and the autonomy of individual states? How do we do that without this powerful provision being misused for political ends?
That's the core tension, isn't it? And this article is inextricably linked to Article 356 and the intensely debated President's Rule. What did the Supreme Court say about its application?
Well, the landmark S.R. Bommai v. Union of India judgment from 1994, which is absolutely foundational to understanding President's Rule, emphasized that Article 356, and by extension the grounds under Article 365, is an emergency power. It's to be used sparingly and reasonably. The court stressed that mere noncompliance isn't enough. It must genuinely lead to a situation where the governance of the state truly cannot be carried on in accordance with the Constitution. The presidential satisfaction that a constitutional breakdown has occurred is not absolute. It is subject to judicial review. The Sarkaria Commission report, which studied union-state relations, also strongly advised caution and restraint in invoking Article 356. So Article 365 underscores federal supremacy or union primacy, but it does so within the stringent constitutional constraints of preventing a genuine breakdown of constitutional machinery. And it serves as a sanction for noncompliance that is ultimately subject to judicial oversight.
It's a constitutional safety valve, but one that has to be handled with extreme care. Moving on to Article 366. If the Constitution is a complex legal document, then Article 366 is our indispensable constitutional dictionary. It's an interpretive clause providing authoritative definitions for terms used throughout the Constitution. Without it, imagine the ambiguity and endless debates over even seemingly simple terms. It brings clarity and precision to a complex legal document.
Indeed, it's a remarkably comprehensive list of terms, spanning everything from agricultural income to union territory. The very basic ingredient for its application is the opening phrase, unless the context otherwise requires. This allows for crucial flexibility, meaning that if a specific article or context clearly necessitates a different understanding of a term, then that specific meaning would prevail. Otherwise, these definitions have pervasive scope. They apply everywhere in the Constitution. For example, The definition of existing law under Art. 366-2010 is vital for Article 372, helping determine which pre-Constitution laws continued. Article 366-22, which defined ruler, was amended following the abolition of privy purses, and perhaps most significantly the insertion of tax on sale or purchase of goods under Art. 366-29A. By the 46th Amendment, fundamentally reshaped state taxing powers. We should probably touch on that.
Yes, definitely. So the object is simple: precision, clarity, and consistency in constitutional interpretation. These definitions are absolutely fundamental to understanding every part of the Constitution, ensuring that key terms are interpreted uniformly across different articles unless, as you mentioned, the context explicitly demands otherwise. It's like a master glossary for the supreme law of the land.
Exactly. Let's take that example of tax on the sale or purchase of goods under Article 366-29A. Before this amendment, the Supreme Court in State of Madras v. Gannon Dunkerley & Co., 1958, had interpreted sale very narrowly. It excluded transactions like works contracts, where goods are used to build something, hire renters agreements, or the transfer of the right to use goods. This created huge revenue losses for states. To overcome this judgment and expand the state's taxing powers, the 46th Amendment Act of 1982 inserted Article 366-29A. This new definition explicitly included these types of transactions within the ambit of sale or purchase of goods for tax purposes.
Wow, that's a huge change from just a definition.
It was massive. This single definitional change profoundly reshaped India's legal and economic realities. It fundamentally altered the allocation of taxing powers and allowed states to tap into new revenue streams. It illustrates how crucial these definitions are and how they can even be amended to reshape not just legal meaning, but also economic realities and federal fiscal relations. This raises an important question. How do these meticulously crafted definitions provide both stability to the constitutional text, yet also allow for the necessary evolution of legal and economic meaning through the amendment process?
That's a truly powerful illustration of judicial interpretation leading directly to constitutional amendment. The Gannon-Dunkerley case is a classic example. It shows how a judicial interpretation of a specific term can have such far-reaching consequences that Parliament must step in to clarify or redefine it. This whole area underscores the vital rules of interpretation, the understanding of legislative intent, or in this case, the intent of the Constituent Assembly, and later, Parliament as the amending body and the paramount importance of precision in legal language in a constitution. If Article 366 is our constitutional dictionary, then Article 367 is the rulebook for reading and interpreting the Constitution. It brings in general principles and external aids for interpretation, ensuring a consistent approach to the text. It avoids the need to reinvent interpretative principles for every constitutional provision, which is a brilliant move for consistency.
Indeed, Clause 1 is a cornerstone. It makes the General Clauses Act 1897 applicable for the interpretation of the Constitution unless the context otherwise requires. This act is a treasure trove, really, of interpretative rules for central acts, covering everything from the definition of person or month to rules about singular and plural. Its application here means constitutional interpretation benefits from established statutory interpretation principles.
So it borrows existing rules.
Yes, for consistency. Clause 2 ensures that references to acts or laws in the Constitution include ordinances, those temporary laws promulgated by the president or a governor. This clarifies their legislative force and ensures they are subject to the same constitutional scrutiny as regular laws. Clause 3 defines foreign state as any state other than India, but with a crucial proviso. It allows the president to declare by order that a particular country or group of countries shall not be a foreign state for specific purposes. This provides necessary flexibility in India's international relations, for instance, with Commonwealth countries. This scope promotes broad consistency in legal understanding across all forms of legislation and international engagements.
The object is clearly to promote consistency and predictability in interpretation, clarify the legislative status of ordinances, and provide a clear yet flexible definition of foreign state to maintain diplomatic agility. These rules apply whenever a question arises about the meaning of constitutional provisions, providing a foundational layer for constitutional analysis. Can you give us a real-world scenario where Article 367's provisions would come into play?
Certainly. If a term like person is used in the Constitution but not specifically defined in Article 366, you'd immediately look to the General Clauses Act, thanks to Article 367, to understand its legal meaning for constitutional purposes, unless the context clearly indicates a different meaning. Or, if the president promulgates an ordinance that restricts a fundamental right, Article 367(2) confirms that this ordinance is indeed a law for the purpose of Article 13, making it subject to fundamental rights scrutiny by the courts. And in the realm of international relations, the president could declare a Commonwealth country not a foreign state for certain specific purposes, like granting reciprocal rights to its citizens within India that wouldn't normally be extended to citizens of a foreign state.
Okay.
This raises an important question, though. How do these general rules, primarily designed for the interpretation of ordinary statutes, effectively accommodate the unique, organic, and often purposive nature of constitutional interpretation, which frequently requires a broader and more dynamic approach? It's a subtle but vital interplay.
That's a great point about the specific challenges of constitutional interpretation. The Supreme Court frequently relies on the General Clauses Act. For instance, in A.K. Roy v. Union of India, 1982, which dealt with the president's ordinance-making power during a proclamation of emergency, the legislative character and force of ordinances were powerfully reinforced, echoing Article 367 too. It's a reminder that while the Constitution is sui generis, unique in its own kind, a fundamental law, it greatly benefits from established rules of statutory interpretation. However, the principle of generalia specialibus non derogant means that specific constitutional definitions, like those in Article 366, or overriding contextual requirements will always prevail over general rules from the General Clauses Act. This reaffirms the supremacy and unique nature of the constitutional text. We talked about how the Constitution clarifies its terms and how it's interpreted, but what about changing it entirely? Article 368 is where the Constitution truly becomes a living document. It's the power of Parliament to amend the Constitution. But it's a power that has been fiercely debated, challenged, and profoundly shaped by the Supreme Court, especially through the now famous Basic Structure Doctrine. It outlines the very mechanism for constitutional change, crucial for any enduring democracy.
You've hit on one of the most dynamic and frankly contested areas of Indian constitutional law. Clause 1 of Article 368 states that Parliament, in exercise of its constituent power, a power distinct from ordinary legislative power, may amend by way of addition, variation, or repeal any provision of the Constitution. This particular clause was actually added by the 24th Amendment in 1971, specifically to overcome the Supreme Court's earlier reasoning in the Glocnath case, which had restricted Parliament's power to amend fundamental rights.
Right, that was a major turning point.
It was. The procedure, outlined in Clause 2, is quite rigorous, highlighting the importance of the document. It requires specific majorities, an absolute majority of the total membership of each House, and a two-thirds majority of those present and voting in each House of Parliament. For certain entrenched provisions affecting the federal structure matters like the election of the president, the distribution of legislative lists between the union and states, or even Article 368 itself, a further step is mandatory. Ratification by not less than half of the state legislatures. The 24th Amendment also made presidential assent mandatory for a constitutional amendment bill to become law.
So it's a high bar, especially for federal issues.
A very high bar. What defines the true scope of this power, however, are the later developments. Clauses 4 and 5, which attempted to declare Parliament's amending power unlimited and to oust judicial review entirely. Well, they were famously struck down by the Supreme Court. This means the scope, while nominally broad, is fundamentally limited by judicial interpretation, ensuring it remains a controlled and reviewable power, not an absolute one.
That's a fascinating evolution of power and counterpower. The object of Article 368 is clearly to allow the Constitution to grow and adapt to society's changing needs, to be a dynamic document, while striking a careful balance between rigidity for stability and the sanctity of fundamental law and flexibility for necessary change. It applies whenever any part of the Constitution is to be amended, ensuring an orderly process for constitutional evolution. Can you give us some key examples that illustrate this power in action?
Certainly. The very first amendment in 1951, which added reasonable restrictions on free speech and introduced provisions for land reforms, was one of the earliest exercises of this power. Later, the 42nd Amendment in 1976, often referred to as a mini-constitution, made sweeping changes, including attempts to curtail judicial review and declare Parliament's amending power absolute. However, as we discussed, some of those key provisions were later struck down. On the other hand, transformative amendments like the 73rd and 74th Amendments, passed in 1992, which institutionalized panchayats and municipalities, significantly altered the federal structure and thus required ratification by the states.
Right, that needed the state's approval.
Exactly. This brings us to a crucial question. How can Parliament, the creature of the Constitution, amend the very document that defines its powers without undermining the fundamental principles and the very identity of the Constitution itself? This is precisely where judicial review, and specifically the basic structure doctrine, plays a critical and defining role in maintaining the constitutional equilibrium.
That question really cuts to the heart of the matter, and you're right, this is perhaps the most judicially active article, leading to some of the most iconic Supreme Court judgments. Let's trace that extraordinary journey.
The story of Article 368 is indeed the story of India's constitutional soul-searching. It began with Shankari Prasad Singh Deo v. Union of India, 1951, and Sajan Singh v. State of Rajasthan, 1965. Here, the Supreme Court largely upheld Parliament's power to amend fundamental rights, holding that an amendment was not law under Article 13(2), which states that laws inconsistent with fundamental rights are void.
So initially, Parliament's power seemed quite broad.
It did. But then came a paradigm shift with I.C. Golaknath and Orr's v. State of Punjab and Ann, 1967. In this case, the court, by a narrow majority, overruled its previous decisions, declaring that fundamental rights were transcendental and could not be abridged by an amendment. It held that an amendment was indeed law under Article 13(2). This led to significant constitutional tension.
A direct challenge to Parliament's power.
Absolutely. In response, Parliament passed the 24th Amendment, explicitly stating that Parliament had the constituent power to amend any provision and that Article 13 would not apply to amendments. This set the stage for the epoch-making case of Kesavananda Harati Sripada Galvaru v. State of Kerala and Enver, 1973. This case, heard by the largest ever bench of 13 judges by a narrow 7.6 majority, overruled Golaknath. It affirmed that Parliament could amend any provision of the Constitution, including fundamental rights, but, and this is the key part, introduced the groundbreaking basic structure doctrine. Parliament cannot alter or destroy the basic structure or fundamental features of the Constitution. The court identified elements like parliamentary democracy, judicial review, secularism, and federalism as part of this basic structure.
The basic structure doctrine, that's fundamental.
Absolutely fundamental. This doctrine was then powerfully applied in Indira Nehru Gandhi v. Rajan, 1975. Here, the court struck down Article 329A4, an amendment that validated Mrs. Gandhi's election retrospectively for violating the basic structure, specifically principles like free and fair elections and the rule of law. And then in Minerva Mills Ltd. and Orrs v. Union of India and Orrs, 1980, the Supreme Court famously struck down clauses 4 and 5 of Article 368, inserted by the 42nd Amendment. Those clauses attempted to make amendments immune from judicial review and declare Parliament's amending power absolute. The court held them to be violations of the basic structure.
So judicial review itself is part of the basic structure.
Exactly. And limited amending power, too. Finally, in Iyer Coelho, Dead, by Ehlers v. State of Tamil Nadu and Orrs. 2007, the court affirmed that the basic structure doctrine applies even to laws placed in the Ninth Schedule, which were traditionally immune from judicial review if they abrogate Part 3 rights for amendments made post-April 24, 1973, the date of the Kesavananda judgment. So the doctrine of basic structure stands as the ultimate implied limitation on constituent power. It ensures that while the Constitution is a living constitution capable of adaptation, it remains within an inviolable foundational framework.
Wow, that's an incredible constitutional saga, truly demonstrating the living nature of the Constitution and the judiciary's role in defining its limits. Now let's transition from the macro-level power of amendment to a series of articles that speak to the specific, often unique arrangements needed to govern a nation as diverse as India. First up is Article 369, another historical gem. This was a temporary grant of power to Parliament to legislate on certain stateless matters as if they were concurrent. What was the thinking behind this, and what was its original nature?
Article 369 was a crucial temporary measure reflecting the early flexibility and pragmatic approach needed for a nascent nation forging its identity. Its nature was to temporarily augment Parliament's legislative competence. For a period of 5 years from the commencement of the Constitution, Parliament was empowered to make laws with respect to certain matters normally exclusively in the state list, things like trade and commerce within a state, production, supply and distribution of goods, and certain taxes, as if they were in the concurrent list. This allowed for national uniformity and coherence in areas where immediate coordinated action was deemed necessary during that critical initial phase.
So it was a short-term solution for immediate administrative and economic needs. It has no current operational force, correct?
That's right. The laws made under this temporary power would cease to have effect after the expiration of the 5-year period. except regarding actions already taken. It highlights its purely transitional nature. It has no current operational force, but it provides a fascinating insight into the constitutional pragmatism of the framers. They were willing to create ad hoc mechanisms to stabilize and integrate the diverse territories of India in its formative years.
Now, no deep dive into these particular articles would be complete without acknowledging Article 370. This was a temporary provision that defined the unique, almost semi-autonomous relationship between the Union and the state of Jammu and Kashmir based on its instrument of accession. A critical note here for our listeners. Its status has significantly changed since the day of our source material, but its original purpose and nature are historically vital to understand its impact on Indian federalism.
Absolutely. Originally, Article 370 granted a special, temporary, and conditional status to Jammu and Kashmir. The basic ingredients of its original scope were quite distinct. Initially, only Articles 1, which declares India as a union of states and names its territories, and 370 itself applied directly to J&K. Parliament's power to make laws for J&K was severely restricted. It could legislate only on matters in the Union list and concurrent list that corresponded to those specified in the Instrument of Accession Defense, External Affairs, and Communications. And for these, only after consultation with the state government. For other matters in these lists, the concurrence of the state government was required.
Consultation versus concurrence, a key difference.
A very key difference. Furthermore, other constitutional provisions could be applied to J&K only via presidential order. And even then, these orders required consultation with the state government for matters related to the instrument of accession and state concurrence for others. A crucial ingredient was that the President could declare Article 370 to cease to operate or apply with modifications, but only on the recommendation of the state's Constituent Assembly. Notably, Article 238, which dealt with Part B states, did not apply to J&K. This complex consultative relationship reflected J&K's unique position at the time of accession and was designed as a phased integration approach.
So, applying fundamental rights to J&K, for instance, required a presidential order with the state government's concurrence, and even that could be modified. It was a very unique, highly specific, and phased integration approach, acknowledging the state's specific historical and political context. This truly shows the adaptability of the Constitution in managing immense diversity during nation building. That adaptability is further evident as we move into the Articles 371 and 371AI. These are a fascinating group of special provisions for specific states, each tailored to address unique historical, cultural, or developmental needs. Let's group them by theme. First, let's talk about those focused on development boards and equitable opportunities. This includes Articles 371, 371D, and 371E. Starting with Article 371 for Maharashtra and Gujarat.
Right. Article 371 empowers the President to make special provisions with respect to the states of Maharashtra and Gujarat. It lays special responsibilities on the governors of these states to ensure equitable development. This includes establishing separate development boards for regions like Vidarbha, Marathwada, and the rest of Maharashtra, and for Saurashtra, Kutch, and the rest of Gujarat. The object is to ensure equitable allocation of funds for developmental expenditure, provide adequate facilities for education and vocational training, and ensure adequate opportunities for employment and services under the control of the state government. It's basically a constitutional mandate for balanced regional growth.
That's a clear constitutional push for internal equity within states. What about Article 371D for Andhra Pradesh? This seems to go even further in addressing regional disparities.
Article 371D is a powerful provision tailored specifically for Andhra Pradesh and later, by extension, Telangana after state bifurcation. Its nature is to provide for equitable opportunities and facilities for people belonging to different parts of the state in matters of public employment and education. It allows for the creation of local cadres in public services, and it established an administrative tribunal to adjudicate disputes relating to appointments, allotments, or promotions in public service. The key aspect here is its overriding effect. It can override other constitutional provisions or laws if necessary to achieve its objective. This demonstrates a deep concern for internal equity within a state, applying context-specific rules for public interest to ensure justice and equality for all citizens within a diverse state, especially to correct historical imbalances.
And a quick, specific one related to education for Andhra Pradesh. Article 371E.
Article 371E is indeed short and sweet. It simply states that Parliament may, by law, provide for the establishment of a central university in the state of Andhra Pradesh. It's a direct constitutional provision empowering the Union to ensure higher education infrastructure in a specific state, highlighting the national interest in regional educational development.
Moving on to our second theme, articles that protect customary law, social practices, and land. These are particularly fascinating because they preserve unique cultural identities within the larger Indian Union. Let's start with Article 371A for Nagaland.
Article 371A for Nagaland is profoundly significant. Its nature is to grant substantial autonomy and protection to the Naga people and their distinct way of life. It explicitly states that no act of parliament concerning Naga religious or social practices, Naga customary law and procedure, administration of civil and criminal justice involving Naga customary law, or ownership and transfer of land and its resources shall apply to the state of Nagaland, unless the Legislative Assembly of Nagaland by a resolution so decides. This is a powerful constitutional recognition and protection of unique cultural identity and autonomy. It's a cornerstone for preserving the distinct way of life of the Naga people within the Indian Union.
A state veto, essentially, on those specific matters.
In effect, yes. Furthermore, the governor of Nagaland is given a special responsibility for law and order in the state, and in discharging this function, the governor must exercise individual judgment, and their decision is final. This responsibility continues until the president directs its cessation. There are also specific provisions for the Twensang district, ensuring its governance aligns with local customs.
That's an extraordinary level of constitutional protection for cultural identity. Now, let's look at Article 371F for Sikkim, which has its own unique story of integration.
Upon its integration into the Indian Union in 1975, Article 371F was inserted as a comprehensive package tailored specifically for Sikkim. Its nature is to ensure a seamless and constitutionally recognized transition for this newly integrated state. It covers a wide array of provisions, from setting the size of the Legislative Assembly not less than 30 members, to the continuance of existing laws and the President's power to adapt them, with such adaptations being non-justiciable. Crucially, similar to Article 363, it includes a bar on court jurisdiction for disputes arising from pre-integration treaties and agreements, giving finality to the political act of merger. It also empowers the President to extend other laws to Sikkim and remove any difficulties, validating all actions taken post-integration. Its object was to provide stability and a clear legal framework during a sensitive period, ensuring Sikkim's unique circumstances were fully addressed while integrating it into the Indian Federation.
And continuing this theme of cultural protection, what provisions are there for Mizoram under Article 371G?
Article 371G for Mizoram provides protections very similar to those for Nagaland. It mandates that no act of parliament concerning Mizo religious or social practices, Mizo customary law and procedure, or ownership and transfer of land, shall apply to the state of Mizoram unless the state legislative assembly by a resolution so decides. These provisions are fundamental to preserving the distinct indigenous cultures and legal systems within the Indian Union, showing a nuanced approach to diversity and self-governance. The underlying object is to safeguard the cultural identity and traditional practices of the Mizo people, allowing them a significant say in laws that directly impact their way of life.
These articles really highlight India's flexible federalism. Now, let's look at our third theme, legislative size and governor's special responsibility. These focus on administrative and representational structures in specific states, starting with Article 371B for Assam.
Right. Article 371B for Assam allows the President to provide for the constitution of a committee of the Legislative Assembly, specifically for the tribal areas of the state. The object here is to ensure their effective representation in legislative functions and to address their unique needs and aspirations within the larger state framework, thereby promoting inclusive governance and protecting regional interests.
And for Manipur, Article 371C seems to have a similar intent.
Yes, Article 371C for Manipur provides for the constitution of a committee of the Legislative Assembly, specifically for the hill areas of the state. The governor also has a special responsibility to ensure its proper functioning, including the making of rules for its procedure. These provisions underscore the commitment to inclusive governance for diverse regions, giving a distinct voice and administrative mechanism to specific communities within the legislative framework and ensuring their concerns are specifically addressed.
What about Arunachal Pradesh under Article 371H?
Article 371H grants the governor of Arunachal Pradesh a special responsibility with respect to law and order in the state. In discharging this function, the governor is required to exercise individual judgment, and their decision is final. This responsibility continues until the President directs its cessation. Additionally, it mandates a minimum legislative assembly size of 30 members for Arunachal Pradesh, ensuring a baseline for democratic representation in the geographically challenging and sensitive border state.
And finally, Article 371I for Goa.
Article 371I is pretty straightforward. It simply sets the minimum size for the Legislative Assembly of Goa at 30 members. It ensures a baseline for democratic representation in smaller states, preventing an unviable or unrepresentative legislative body, while also recognizing Goa's unique history as a former Portuguese colony.
So what does this all mean when we connect the dots across Part XE1? These articles aren't just a random list. They tell a truly compelling story. A story of India grappling with its immense diversity, managing the complex integration of princely states, reorganizing its territories, and protecting unique regional and cultural identities, all within the overarching constitutional framework. They reflect a remarkably pragmatic and adaptable approach to nation building, acknowledging that a one-size-fits-all approach simply wouldn't work for such a vast, varied, and pluralistic nation. It's constitutional flexibility in action.
Very well put. That adaptability is key.
That flexibility continues as we move into the articles focused on continuity and transition, the true legal foundation of the new republic. Article 372 is a genius move for legal continuity. Why do you call it a genius move, and what was its core concept?
I call it a genius move because it prevented a potentially catastrophic legal vacuum at the very birth of our republic. The core concept is one of seamless legal continuity. It essentially declared, don't worry, all those laws you know and live by, they're still valid. Without Article 372, every single law enacted by the British or by colonial legislatures would have, theoretically, ceased to exist upon the commencement of the new Constitution. That would have led to utter chaos. It ensured that the existing legal framework didn't abruptly cease to exist, providing stability and order.
That foresight seems incredibly practical. What were the basic ingredients and scope that allowed this massive legal transition?
Well, it specified that all law in force immediately before January 26, 1950, our Republic Day, would continue to be in force. This was despite the repeal of the Government of India Act 1935 and the Indian Independence Act 1947 by Article 395. But here's the crucial interpretive ingredient. This continuance was subject to the other provisions of this Constitution. This meant that any existing law had to conform to the new supreme law of the land, especially fundamental rights.
The supremacy clause kicking in immediately.
Precisely. The president was also granted a temporary power, initially for 2 years later, extended to 3 by the First Amendment, to adapt these existing laws through orders. This was to bring them into accord with the new Constitution. These adaptations were generally non-justiciable. The explanations further clarified law in force to include laws with extraterritorial effect and those not yet brought into operation, but excluded temporary laws beyond their expiry. This was a truly comprehensive approach to managing a national legal transition.
So the object was a smooth transition, preventing chaos and allowing the newly formed legislatures time to review and update laws, while also immediately subjecting them to the new constitutional order. Can you give us a powerful illustration of this, especially regarding how existing laws clashed with new fundamental rights?
Absolutely. Think about our core legal framework. The Indian Penal Code, 1860, the Contract Act, 1872, the Evidence Act, 1872. These fundamental statutes continued seamlessly under Article 372. The President's adaptation of Law's Order, 1950, made necessary formal changes, like substituting Crown with government in various statutes.
Okay, routine updates.
Yes. But here's the clash. Imagine a pre-constitutional law that, for instance, discriminated on the basis of religion, maybe a local regulation from the British era. Under Article 372, that law would continue to be in force. However, because it was also subject to the other provisions of this Constitution, specifically fundamental rights, like Articles 13 and 15, which prohibit discrimination on grounds of religion, that discriminatory law would become void from January 26, 1950, to the extent of its inconsistency. This raises an important question. How do we reconcile the need for legal continuity, which preserves existing norms, with the immediate and powerful enforcement of new constitutional values and fundamental rights that might contradict them?
That's a fascinating tension. And the Supreme Court addressed this directly, didn't it, with the doctrine of eclipse?
Indeed. The Keshavan Madhava Menon v. State of Bombay case, 1951, is key here. It introduced the doctrine of eclipse. The court held that pre-Constitution laws inconsistent with fundamental rights weren't entirely dead or repealed. Instead, they were eclipsed or overshadowed. They became inoperative and void only from the Constitution's commencement and only for future application. If the constitutional impediment, the inconsistent fundamental right, were ever removed or amended, the eclipse law could potentially revive. It's a classic case of balancing the doctrine of legal continuity with the supremacy of the Constitution and the pragmatic concept of adaptation of laws.
So the old laws continued, but they had to instantly conform to the new constitutional values or risk being eclipsed. That's a brilliant way to manage such a monumental transition. Now, Article 372A, this is a special one-time power, a corollary to Article 372, inserted by the Seventh Amendment, specifically for adapting laws after the massive States Reorganization Act of 1956. What was the purpose of this highly targeted time-bound power?
Right, the States Reorganization Act of 1956 fundamentally redrew the political map of India, creating new states and altering boundaries on linguistic lines. This massive restructuring meant that countless existing laws, which referred to old provincial or state names and administrative structures, instantly became incongruous. Article 372A was inserted precisely to address this. It gave the president a special time-bound transitional power to adapt, repeal, or amend existing laws that were in force before November 1st, 1956. The aim was to ensure they conformed with the Constitution as amended by the Seventh Amendment. Its object was to provide a swift and efficient mechanism for the president to make the consequential adaptations needed for existing laws to correctly apply to the new political map of India.
So the president could essentially update the legal address book of the entire nation after reorganization. What was the time frame for this and what's its status now?
Well, this presidential power, exercised by order, could repeal or amend existing laws. And these adaptations were explicitly stated not to be questioned in any court of law, emphasizing its transitional administrative nature. However, that this power was strictly time-limited and expired on October 31st, 1957. So it's purely historical now, but it's crucial for understanding the legal restructuring of that era. The president issued significant adaptation of laws orders in 1956 and 1957 under this article, making changes like substituting new state names for old ones in various statutes. It effectively ensured the legal framework remained congruent with the new territorial realities. It's a clear example of adaptation of laws and transitional justice within a legal framework, demonstrating how the Constitution can provide specific mandates for restructuring. Next, Article 373. This was another temporary measure, allowing the president to make orders regarding preventive detention. This points to the urgency of some issues in the early republic. What kind of gap was it bridging? Preventive detention was an incredibly sensitive and pressing issue in the turbulent post-partition era. Seen by some, rightly or wrongly, as a necessary evil for national security and public order. Article 373 was a temporary provision granting the president interim legislative-type powers in this area. It bridged the gap by ensuring an immediate legal framework, including the operationalization of safeguards like advisory boards under Article 22, even before Parliament had the time to pass its first comprehensive Preventive Detention Act in 1950. The object was to ensure an immediate legal framework for preventive detention and its constitutional safeguards.
So it provided immediate procedures until proper legislation could be enacted. What was its operational life?
Very short-lived. Its operational force ceased, either when Parliament legislated on preventive detention or after 1 year from the commencement of the Constitution, whichever came earlier. It's now purely historical, but highlights a rare instance of the president exercising interim legislative-type powers to deal with an urgent national matter. The early Supreme Court cases, such as A.K. Gopalan v. State of Madras, 1950, which dealt extensively with Article 22, were adjudicated in the context of this immediate operationalization of preventive detention. It exemplifies transitional provisions and a rare instance of executive power in lieu of legislation. Temporary.
Now, let's talk about judicial continuity, starting with Article 374. This is all about ensuring a seamless transition at the highest level of the judiciary, from the old federal court to the new Supreme Court, and crucially, formally ending the Privy Council's jurisdiction over India. Why was this so important?
Article 374 was designed to establish the Supreme Court as the undisputed final arbiter of law, ensuring no disruption in the administration of justice. Its core nature was a comprehensive transitional provision for the smooth establishment of the Supreme Court. The basic ingredients were meticulous. Federal court judges automatically became Supreme Court judges unless they opted otherwise, and were entitled to new salaries and allowances under the new Constitution. All suits, appeals, and proceedings pending in the federal court were automatically transferred to the Supreme Court. Even judgments of the federal court were given the same force as Supreme Court judgments, providing crucial continuity in judicial precedent.
And the Privy Council link.
Yes. Critically, it addressed the appeals pending before the Privy Council in London. It ensured their disposal, as if by the new Supreme Court, and explicitly ceased the Privy Council-like jurisdiction that had existed in some Part B states. The object was a seamless judicial transition, preventing any disruption in ongoing cases, and firmly establishing the Supreme Court as the undisputed new apex court. It defined precedence and continuity for years and formed the bedrock of India's unitary judicial system. This is a prime example of judicial continuity and succession of courts, ensuring that a change in constitutional systems doesn't break the legal chain. It's also about the fundamental transfer of jurisdiction.
Following that, Article 375 is a sweeping yet subtle provision. It essentially said every court, authority, and officer, civil, criminal, revenue, judicial, executive, continued to function. But it came with a critical condition, subject to the provisions of this Constitution. Why was that condition so important?
That condition is everything, really. Article 375's core nature is a general transitional provision, ensuring the uninterrupted functioning of the entire governmental and judicial machinery. Without it, the new republic would have faced immediate administrative and judicial collapse. It meant that a district judge, a police officer, a revenue collector, or any other civil servant continued their duties. However, the critical caveat, subject to the provisions of this Constitution, meant that from day one, their actions had to conform to the fundamental rights and all other constitutional provisions. It's an implicit, powerful mandate for conformity, asserting the supremacy of the Constitution over all existing organs of the state. It ensures that the old order seamlessly integrated into the new constitutional discipline. This is the bedrock of legal and administrative continuity, and it fundamentally underscores supremacy of the Constitution. It served as an implied mandate for conformity. Everyone continued, but under new rules.
And similar to Article 374 for the federal court, Article 376 specifically ensured the continuity of high court judges, both from British Indian provinces and former princely states, into the new constitutional setup. This was vital for maintaining the functioning of the state-level judiciary, wasn't it?
Absolutely. Article 376 was designed for a smooth transition of the high court judiciary. Judges from provincial high courts automatically became judges of the corresponding state high court, with new salaries and allowances specified by Article 221. A pragmatic proviso even allowed non-citizen judges to continue a practical move to retain experienced personnel during the early days. Judges from high courts in former Indian states also transitioned, but their tenure was initially determined by presidential order, reflecting the varied legal systems they came from before integration. This ensured stability by retaining experienced personnel while standardizing their service conditions where possible, thereby strengthening the rule of law across the new republic. This is another instance of judicial continuity and the integration of judiciary, demonstrating meticulous planning in nation building.
Next, Article 377 is a very specific transitional provision for the head of India's audit institution, the Auditor General. What was the purpose of ensuring seamless continuity in this vital financial oversight role?
Well, the role of an independent audit institution is paramount for public trust and effective governance. Article 377 ensured that the incumbent Auditor General automatically became the first Comptroller and Auditor General CAG of India, unless they opted otherwise. This individual enjoyed the new constitutional salaries and rights under Article 148(3), but completed their original pre-Constitution term. The object was clear: seamless transition and continuity in financial oversight, preventing any vacuum in this crucial role, and ensuring clarity on the first CAG's status from day one. It's now historical, but its impact on financial accountability was immediate and profound, setting a strong precedent for independent oversight. This is a clear case of continuity of constitutional offices, crucial for financial accountability and oversight.
And Article 378 mirrored this continuity theme for public service commissions, both the UPSC at the union level and state PSCs. What was the thinking behind this?
Public service commissions are vital institutions for ensuring impartial recruitment to public services and advising the government on service matters. They form the backbone of a merit-based bureaucracy. Article 378 ensured the uninterrupted functioning of these institutions. Members of the Dominion Public Service Commission became UPSC members, and Provincial Public Service Commission members became state PSC members, unless they opted otherwise. They continued their original terms but became subject to the new constitutional provisions for resignation and removal, aligning them with the new constitutional framework and safeguarding their independence. The object was to ensure uninterrupted, impartial recruitment and advice to government on service matters, establishing the integrity of public administration from the outset. This is another powerful example of continuity of institutions and transitional justice personnel, upholding the independence of PSCs.
Finally, in this section, we have Article 378A. This is another unique, specific provision related to the 1956 states reorganization. It fixed the duration of the Legislative Assembly of the newly reorganized state of Andhra Pradesh, overriding the general rule of Article 172. Why was such a specific ad hoc provision necessary?
Article 378A illustrates the Constitution's granular approach to administrative restructuring. The reorganization of states created new, sometimes complex political realities. Its object was to provide a clear and fixed term for the first legislature of the newly configured state of Andhra Pradesh. This offered crucial stability during its formative period, given the complexities of territorial reorganization and the need for new administrative alignment. It essentially overrode the normal Article 172 duration to provide that specific certainty. While it's now historical, it demonstrates how the Constitution made specific ad hoc provisions for major administrative restructuring to address unique transitional challenges and maintain stability. This is an example of special constitutional provisions and transitional arrangements for state legislatures.
And a quick note for our listeners. Articles 379, 391 were also part of the original Constitution's transitional provisions, but were subsequently repealed by the Constitution, 7th Amendment Act, 1956. They had served their purpose once the transition was complete. So another set of articles designed for a specific moment in time. That brings us to the final part of our deep dive, the formal touches and repeals in Part XD2. And we start with Article 392, which granted an extraordinary temporary power to the President and initially the Governor General to literally adapt or modify the Constitution itself. This was for removing unforeseen difficulties during the transition from the old British legal framework to the new Constitution. A real Henry VIII clause in a constitutional context. Why was such a broad power necessary?
It was a recognition of the inherent unpredictability of such a monumental transition. The framers knew that despite their best efforts, unforeseen procedural gaps or technical hurdles would emerge as the new constitutional machinery began to operate, shifting from the Government of India Act, 1935. The nature of Article 392 was a temporary transitional provision empowering the President and the Governor General before commencement to adapt or modify the Constitution by order.
Adapt the Constitution itself, temporarily.
Yes, temporarily. The basic ingredients and scope were precise. The President could direct the Constitution to have effect with such modifications, additions, or omissions as appeared to be necessary or expedient for removing any such difficulties. But, crucially, this power was strictly time-limited. It ceased after the first meeting of Parliament elected under the new Constitution. Any orders made had to be laid before Parliament, ensuring some level of oversight. Clause 3 even allowed the Governor-General to exercise this power before the Constitution commenced, for preparatory work, for instance, in relation to articles like 324 Election Commission or 391 Provisional Parliament. It shows immense strategic foresight. This power was for specific transitional difficulties, not a general amending power.
So the object was a smooth and effective transition, preventing the nascent constitutional machinery from getting stuck on unforeseen technical hurdles. It was crucial in the early 1950s, but is now historical, having served its purpose of navigating the initial challenges. Can you give us an example, and what important question does this power raise about executive authority?
Well, early removal of difficulties orders were indeed issued to clarify procedural gaps. For example, regarding the composition and functioning of the Provisional Parliament, or adapting existing constitutional provisions to ensure they work smoothly from day one. Courts have generally interpreted such clauses very narrowly, emphasizing they are for genuine difficulties and not to facilitate substantive amendments that should properly go through Article 368.
Right, not a backdoor for major changes.
Exactly. This raises an important question for any constitutional democracy. How much power is too much to give the executive, even temporarily, over the foundational document? And what mechanisms are needed to prevent its overreach? In India's case, the strict time limit and parliamentary oversight were the key checks. This clause is justified by the doctrine of necessity for a new constitution. It acts as a form of conditional legislation or power of adaptation, but always with recognized limitations on removal of difficulties clauses. It was definitely not a free pass for fundamental changes.
From the profound to the precise, Article 393 is next. Simple, yet fundamental. It gives our Constitution its official name, the Constitution of India. Pure and precise nomenclature, establishing its identity. What's its object and applicability?
Its object is purely functional, to ensure clarity and uniformity in reference. It provides a convenient and authoritative short title for the supreme law of the land in all official and legal contexts. It applies universally whenever the Constitution is cited, establishing its formal identity without any ambiguity. It's a formal naming, not open to legal dispute.
Article 394 is critical. It tells us when the Constitution actually came into force. But here's a twist. It was a two-stage commencement. What was the strategic thinking behind that?
That two-stage commencement was indeed a strategic stroke of genius. The Constitution was not implemented all at once. Certain articles, particularly those essential for the immediate establishment of the new republic and for managing the transition, came into force at once on November 26, 1949. This was the day the Constituent Assembly adopted the Constitution. These included Articles 5 to 9 Citizenship, Article 60 Presidential Oath, Article 324 Election Commission crucial for future elections, Articles 366 and 367 Definitions and Interpretation, and some key transitional provisions like 379, 380, 388, 391, 392, and 393.
So the bare essentials for starting up.
Exactly. All remaining provisions, including the vast majority of the Constitution, such as fundamental rights and directive principles, commenced on January 26, 1950. This date was strategically chosen as the commencement of this Constitution because it was Purna Swaraj Day, the day the Indian National Congress had declared independence back in 1930. This dual commencement shows remarkable foresight for the transition, prioritizing the immediate operationalization of critical aspects while giving time for a full, symbolic, and formal launch.
So the object was to immediately operationalize essential provisions for the transition, like citizenship and the Election Commission, to prepare for future elections, while also celebrating January 26th as the formal birth of the Republic. It's crucial for determining the applicability of laws and rights around those dates. The Keshavan Madhava Menon case we discussed earlier, for example, implicitly recognized these commencement dates when dealing with pre-Constitution laws and fundamental rights. This article is all about the commencement of statutes and very careful transitional provisions. Now, Article 394A, added later in 1987, is a nod to India's official language policy. It mandates an authoritative Hindi translation of the Constitution and all its amendments. Why was this important, and what does it achieve?
Article 394A was inserted by the 58th Amendment, reflecting the constitutional aspiration of promoting Hindi as an official language and ensuring accessibility. It mandates that the President must publish a Hindi translation of the Constitution, ensuring it aligns in style and terminology with other central acts in Hindi. This translation must incorporate all amendments. Crucially, this Hindi text is legally deemed to have the same meaning as the original English text, with a mechanism for revision if any difficulties arise in its construction. This elevates the Hindi text to authoritative status alongside English, effectively establishing a bilingual authoritative text of the Constitution. The object is to promote Hindi, make the Constitution accessible to a broader section of Hindi speakers, and provide a definitive Hindi legal text. Both English and this published Hindi version are now authoritative, offering citizens a choice of official texts. This deals with authoritative text of statutes and the official language policy. It also implicates interpretation of bilingual legal texts to ensure consistency between versions.
And finally, the last article in our deep dive, Article 395. This is the constitutional mic drop. It formally repeals the British-era foundational laws, the Indian Independence Act, 1947, and the Government of India Act, 1935. What was the significance of this definitive legal severance from the colonial past?
Article 395 is arguably the ultimate declaration of India's complete constitutional sovereignty. It explicitly repealed these two major British parliamentary statutes, along with their amending and supplementing enactments. This act was the definitive legal severance from the previous colonial constitutional order. Notably, it didn't repeal the Abolition of Privy Council Jurisdiction Act, 1949, because that was an Indian act, not a British one. This specific exclusion confirmed the termination of external appellate jurisdiction. The object was to formally end the legal authority of the old order, establish the new constitution as the sole and supreme Grundnorm, the fundamental foundational law of the nation, and signify India's complete constitutional sovereignty. It took effect on January 26, 1950, and stands as a landmark historical declaration of self-governance.
A clean break, constitutionally speaking.
A clean break constitutionally, yes. It's vital to remember, however, that while these constitutional acts were repealed, many ordinary laws that were made under the 1935 Act continued in force under Article 372. This shows a nuanced approach to transition, ensuring administrative continuity even as the constitutional framework was entirely replaced. This is all about repeal of statutes, marking a clear legal discontinuity with prior constitutional order and the ultimate declaration of constitutional supremacy as the new foundational law.
Wow. What an incredible deep dive into the foundational legal architecture of India. From the personal immunities that shield our highest office holders, and the dramatic story of how princely states were integrated, to the supreme power of amendment that transformed India into a truly dynamic republic, and the intricate mechanisms for legal continuity and adaptation, we've covered the crucial constitutional nuts and bolts that often go unnoticed but literally hold the nation together.
Indeed, we've explored the very nature, object, scope, application, interpretation, basic ingredients, illustrations, scenarios, and the vital case laws that define these articles. It's a testament to the profound foresight and remarkable adaptability embedded in the Constitution, allowing it to navigate some of the most profound transitions any nation has ever faced, all while upholding its core principles of justice, liberty, equality, and fraternity. These are the silent yet powerful guardians of India's democratic journey.
So, as you reflect on these temporary, transitional, and special provisions designed for specific, often tumultuous historical moments, consider this. How do they continue to influence the very fabric of governance, the balance of power, and even India's national identity today, even if many are now historical? And what does their story tell you about the enduring power and adaptability of a well-crafted constitution to not just survive, but to guide and shape a nation's destiny through centuries of change?
We truly hope this deep dive encourages you, our listener, to look beyond the headlines and explore the intricate, often ingenious, details of legal frameworks. There's always more to learn, and understanding these specifics truly enriches your appreciation of a nation's complex legal journey and the enduring wisdom embedded in its founding document.
Keep digging, keep questioning, and keep getting well informed.
Oh.
We'll be here for your next deep dive into the fascinating world of knowledge.